And one thing that could complicate them taking another case, at least soon, is the main story we're going to talk about today is something that you reported on. It's sort of the latest development in the criminal justice implications of Bruin. We have an appellate court ruling on nonviolent felons. So if you want to tell us about what happened in that case.
Yeah, it's interesting because this case applies, it's a criminal case, and it applies specifically to the defendant who actually didn't commit a felony. So it's probably the easiest way to explain it in a headline is calling it nonviolent felons, because that's the people who are going to be implicated, I think, by this ruling. But technically, this guy committed a misdemeanor. His name is Range, or his last name's Range. He lied on an application for food stamps in Pennsylvania in the 90s, in 1995, and pled guilty to doing that. It was a misdemeanor. However, it was a misdemeanor that carried a potential sentence of up to 5 years in prison. And so under federal law, anything that's a felony that's punishable by more than a year in prison makes you prohibited for life, or a misdemeanor that's punishable by more than 2 years in prison makes you a prohibited person for life. You can't buy guns or possess them. And this guy, even though he never actually served any jail time at all, he got 3 years of probation, and he had to pay less than $3,000 in fines and restitution. So I think most people would look at this as a fairly minor crime. The problem was that he wasn't poor enough to qualify for the food stamps. He was like on the edge of qualifying, but he didn't actually qualify. And so they lied about how much he made. And that's what his crime was. And he hasn't committed any other serious crimes since then. I think he got caught fishing without a license once, but and he has some parking tickets as well. But they ruled that this was not a crime that could be used to prohibit somebody from owning guns for the rest of their life. That was the bottom line ruling. There wasn't a historical tradition for that. They found that Range is part of the people who are protected in the Second Amendment. That's been an ongoing legal discussion about how to deal with felon in possession crimes, because some people argue that, the Supreme Court has talked a lot about law-abiding people being protected by the Second Amendment. And so what exactly does that mean? Who are the people that the Second Amendment protects? Does that include people convicted of serious crimes? And in this case, they didn't really generalize a ton. They kind of took Range's specific situation and just said, this guy is clearly not, a serious criminal. He's clearly part of the people, and there's no history of banning someone like this from owning guns for the rest of their lives. So that's where it came down. And, the implications of that, I think, are that most nonviolent felons are going to fall into a similar category of people as Range.
Yeah.
Even though that the ruling doesn't specifically say that the implication of the ruling, I think, is that basically.
And that's why I think that this is really interesting, because it could prompt the Supreme Court to step in because of that, what you said, that they didn't specify what exactly makes you not part of the people based on offense, because we now have a circuit split on this question. The Eighth Circuit took up a similar nonviolent felony case, and they refused to kind of parse out the difference between violent and nonviolent in order to uphold the felon in possession ban. Whereas this, as you said, this is just an as-applied challenge. They didn't strike down the law. They just said it doesn't apply to this particular guy. But they did, in this case, separate him from, this nebulous category of felon by saying, well, his offense, it's nonviolent. That doesn't count as, you shouldn't be disarmed for that. And so you could see if this does become a persistent challenge by folks that have felony or felony equivalent offenses challenging their conviction, you might see the Supreme Court have to step in to settle, who is the people, what counts as the people.
Yeah, that's a very good point. This could be another, there's a lot that's piled up now that are sort of ripe for Supreme Court review already. I think Rahimi and the Fifth Circuit, which is about the domestic violence restraining orders, that's probably the most likely to get heard next. I think they're going to consider that in this upcoming conference here, whether or not to take up that case.
Yep.
And because that's a federal law, similar to this, I guess, actually, and that this is, they didn't, it's a little different because, as you said, it's more of an as applied situation. They didn't strike down the entire section of federal law that deals with this, but they just said in this guy's case, it doesn't work. And so, yeah, you got a lot of litigation over the federal felon in possession laws at this point, or prohibited persons lists. And yeah, there has been disagreement. So perhaps this is where we'll start seeing, I know most gun rights advocates want the court to start taking up assault weapons bans or magazine limits, or some of these other maybe gun licensing, purchase permits, those sorts of things. But it seems more likely that they're going to have to deal with these prohibited persons categories before they go to all that stuff.
Yeah, I think that's a great point. I've been noticing this too. As soon as Bruin was handed down and the new test was created, gun rights advocates immediately got excited about what does this mean for assault weapon bans or magazine bans, all the policy stuff. And it's just funny to see that it's actually become more of a pileup of criminal justice type cases where it's trying to flesh out 922G, which is the Gun Control Act provision that governs who can and can't own firearms, and it's just become almost entirely focused on that stuff. So I think that is an interesting point.
Yeah, and honestly, there's more bipartisan agreement on that area. I know not necessarily in our sort of everyday politics in terms of what you see on the news or politicians talking about this stuff, but in the courts, this ruling was, I think it was 11-4, and it had a number of Democratic appointees were in the majority. And so you had Obama appointee, you had a Biden appointee, and a Clinton appointee in there as well. So, I think there is some movement from the left on Bruin noticing it as kind of a criminal justice reform element, that they could use this to try and go after some of the more burdensome prohibited person categories, and the way that they're often used disproportionately against minorities is a common complaint about a lot of laws that sort of gets ignored when it comes to gun laws. But maybe they're starting to change their mind on this, or maybe they feel like they don't have another option anyway, so they might as well try to use this in the way that they like.